here so that I can share my ideas, experience of over last 7-8 years in the IP litigation. Thanks to Tusha for the warm introduction. And I won't take much time of yours because I'm sure everyone would be in a hurry to take back their flights for their home. So I'll just start. Though Tusha has already thrown some light on the kind of damages which are there in the IP laws, I'll just take you quickly through the slides. So nominal damages are given when the aggrieved parties awarded a small or symbolic sum for the losses suffered on being able to establish a case for infringement, but having not provided sufficient evidence for suffering those actual losses. Compensatory damages are given by the courts to restore the aggrieved plaintiff party to its real position where it was. And the punitive damages are granted as exemplary damages, which, as Tusha has also mentioned, this is a recent phenomena which has just started. So the courts are awarding these damages in addition to the actual damages and compensatory damages. The punitive damages, of course, have a more deterrent effect on the infringers, pirators. It is a kind of punishment, and based on the theory that the interest of the society and individuals' harm can be met by imposing additional damages on the defendants. Then these are few sections. So under the Patent Act, section 108 talks about the court's power to grant damages in infringement suits, though there is no particular or specific section how to calculate the damages. However, based on the judicial trends, these are the bases which have been identified so far. So the defendant's profits owing to the infringing activity, actual and prospective loss, cost to the claimant, including business and reputation loss, the reasonable royalty that the defendant would have had to pay to the claimant if they had entered into a licensing agreement. Similarly, in trademarks, section 135 talks about the trademark, the damages which can be granted by a court in a trademark infringement and passing of suit. So again, no specific provision, method, formula is given under the Act to calculate, but these can be the basis. So loss sustained by the plaintiff resulting from the natural or the direct consequences of the infringement activity, drop in the trade of the plaintiff pursuant to the infringement activities of the defendant. This is, of course, exclusive of any market scenario, market forces. Then the impact on the goodwill and reputation of the plaintiff resulting from the infringing activity of the infringer. Under the Copyright Act, section 35 deals with the damages part. No specific provision is there, but the basis which the courts have recognized so far could be the plaintiff's profits earned by the infringer, the monetary losses suffered by the copyright owner, and the moral rights of the copyright owners. Design Act, slightly it's different. So under section 22(2) of the Design Act, the provision is given for damages. So if any person acts in contravention of this section, he shall be liable for every contravention to pay the registered proprietor of the design a sum not exceeding 25,000 rupees recoverable as a contract debt. Or if the proprietor elects to bring a suit for recovery of damages for any such contravention and for an injunction against the reputation thereof, to pay such damages as may be awarded and to be restrained by injunction accordingly. So in the first scenario, the provision is given, but the amount is only 25,000. So it's a time like when the courts are really required to pay more damages, to grant more damages to the plaintiff, because this amount will obviously not suffice the litigation cost. And there's a proviso added in this act, in the section, that the total amount recoverable in respect of one design under clause A shall not exceed 50,000 rupees. So that is the place where the need of exemplary and punitive damages comes. And this is the trend, this is a journey of Indian courts, like how the damages have been granted so far. So from 1958 to 1991, very nominal damages were being awarded by the Indian courts. So I would just remind my audience here about the Ruston versus Zamidara engineering case. It was 1969 when the Supreme Court had granted 100 rupees damages to the plaintiff, which is not even $2 as per the current rate. So from 1991 to 2002, where the change had actually come, so as a result of the liberalization policy of the government, many MNCs and foreign entities, they entered into the Indian market. This led to the filing of more IP suits claiming damages, and the concept of transborder reputation was first time recognized. Then in the year 2002, the original jurisdiction of the Delhi High Court was increased up to rupees 20 lakh, which meant that the minimum amount of damages for bringing a suit within the jurisdiction of the High Court has to be 20 lakh rupees at least, and this actually resulted in further increase of grant of damages. And after that, from 2015 to 2018, the jurisdiction of the Delhi High Court was increased from 1 crore to 2 crores respectively, which meant that now the minimum amount of damages which are required to be claimed in an IP suit were 2 crore rupees, and obviously it led to enhancement of damages. These statistics have already been shared by Tusha in her slides. How much damages the courts have granted, Delhi High Court has granted in respect of each industry. So there is a need, which I feel there is a need to include statutory provisions for grant of damages in the acts itself, which will help in to create a greater deterrence against IP violators, deter counterfeiting effectively, assist in calculating exact damages, curb any case of infringement despite the plaintiff's inability to prove compensatory damages. So just before this session, we were having a general discussion with our co-panelists that when the infringement is about a counterfeit of a very high luxury brand bags, then how to calculate the damages. Obviously, the consumer of a high luxury brand is not going to be duped with the counterfeit products which are available in the spurious market. So there is no direct damage which we can prove that the plaintiff has suffered. But yes, of course, there will be damage to the reputation, to the goodwill, and there will be brand dilution. So these are certain ways, and of course if the statutory damages are included under the law, then there will be consistency in the grant of damages in all the IP suits. Then I'll take you to few case studies. So this is HUL versus Reckitt Benckiser India case, which was dealt in the Delhi High Court. The Delhi High Court followed the principle of Rooks and Castle, which was also affirmed by the Supreme Court in some other case, and these principles were that the burden of proof rests upon the plaintiff to establish the facts necessary to bring its case within the following criteria, and the criteria were the unconstitutional action of the defendant, wrongful conduct of defendant which may exceed the compensation payable to the complainant, and any case where exemplary damages are authorized by the statute. Then the next is the court should be satisfied that the punitive or exemplary element has not sufficiently met within the figure that they have arrived for the plaintiff's solatium. Then the total figure awarded should be in substitution for and not in addition to the small figures which would have been treated as adequate solatium, and that the amount of the punitive and exemplary damages are going into the pockets of the brand owners and not to the state, not as adding to the state revenues. Then this is a Glenmark versus CureTech case, which were dealt in the Bombay High Court. So in this case, the Bombay High Court granted damages of rupees 1.5 crores to the infringer since he was a habitual offender and with a set modus operandi of copying brands of various other companies to make profits. At the request of the plaintiff, the court this amount was donated to the Chief Minister's Kerala Flood Relief Fund. Rest, the kind of community services the courts have recognized have already been covered by Tusha, which also include Kar Seva in Gurdwara and few others. This is another example of the Gold's Gym, which is the leading gym brand in US, versus one of the Indian infringer based in New Delhi. In fact, these were two cases taken up together throughout during the trial, during the final conclusion. So in this case, the court had granted damages of rupees 10 lakhs each to the plaintiff and against the defendants, and the court held that the defendants have infringed the plaintiff's trademark along with the design of a man placed inside the circle, basically their logo, which was deceptively similar, and the damages were granted. Then the damages as a remedy in US, I'll slightly touch the scenario which is prevalent in US about the grant of damages. So under the copyright law, the copyright owner's actual damages and any additional profit which was made by the infringer, and the statutory damages which are being granted. Under the patent law, actual damages are being granted. There's a provision for that at least. And the reasonable royalty for the unauthorized use under the trademark laws and accounts of profit. Then the damages including the possibility of tribal damages when appropriate, and attorney's fees in exceptional cases. Damages as a remedy in India, I'll take you through just two case studies. In 2016, Tiffany and Company was awarded 8.25 million USD as punitive damages for willful and bad faith infringement of their trademark by defendant Costco Wholesale Corporation by a jury in US. And in the year 2018, the jury awarded energy drink maker Monster Energy 5 million USD as punitive damages against Integrated Supply Network after Monster Energy proved that Integrated Supply acted with malice, operation and fraud. Then this is a checklist for the IP owners, that what they are supposed to basically the preparation which they are required to do before filing the IP suits. So proof required in the court of law to get damages: plaintiff's sales and advertisement figure for previous years, basically their turnovers for last few years. Then drop in the sale of the plaintiff due to violation of their IP rights. Then customer feedback about the infringer's fake, counterfeited, pirated products to show the harm caused to their brand and reputation. Then track record of the infringer, basically if it's a habitual infringer, what other kind of brands he is owning. Then estimated profits of the infringer, which would include the number of infringing copies sold by the infringer, and inventory of finished goods and packaging materials so seized by the local commissioners during the raid. These are the factors which would help in actually computing the damages. Then there's, apart from damages, the another remedy provided under the acts is the rendition of account. So the remedy of accounts of profits require the defendant to disclose to the plaintiff and the court the actual amounts of profit earned by them owing to the infringing activities. Till now, this was a challenging task for the plaintiffs to ascertain, because the infringers would never maintain their proper accounts. However, due to the transformation in nature of business, the same can now be calculated through the GST returns of the infringer, still if they maintain. The customs import and export database of the infringer, if we are able to retrieve that. Number of hits on the infringer's website and information from the e-commerce marketplaces. So the number of hits was one of the main ground in the famous Cartier case, right? So based on the hits which were received on the defendant's website, the court had calculated the damages, and this has become now a regular practice to calculate the damages. And of course, if the infringing goods are being sold on e-commerce platforms, then certain data can also be received from these e-commerce marketplaces. Now this is slightly beyond the damages which are being awarded in the IP suits. So I'll say that infringement has traveled beyond the boundaries of IP. Recently, a major direct selling company giant, Amway India, has filed various lawsuits in the Delhi High Court alleging that the acts of the defendants, including the e-commerce portals, selling the goods on the resale shops, stores, or the e-commerce portals were in violation of their direct selling guidelines 2016 formulated by the Ministry of Consumer Affairs India. So the major issue in these suits were the unauthorized sale of their goods in violation to their direct agreement with their direct sellers, the impairment and tempering of goods. So what these sellers were doing, they were tempering the unique codes imprinted on the Amway products, and they were selling these products on various e-commerce portals, and were earning huge margins out of it. And the return and refund policies of the e-commerce were obviously different from the brand owners. So this is not a direct case of infringement, yes, of course, but these are tortious interference with the legitimate business of the brand owners. And the reliefs which were granted by the courts, these are similar to what we get in IP suits. But yeah, so one of the relief was that for the first time in India, a John Doe injunction was granted in a non-IP suit against the defendants for selling their products in violation of the direct selling guidelines. Pursuant to the orders, raids were conducted in various notorious markets of Delhi, where the Amway products were being sold on huge discounts. And the e-commerce companies and their resellers were enjoined from displaying, selling, offering for sale of Amway products on their various platforms. They were directed to take down all the listings of Amway products from their platform within a stipulated time period. Various local commissioners were appointed to visit the premises of all major e-commerce giants to take the database of the goods they have sold so far, to retrieve their agreements with these sellers, and basically to get the disclosure of the sources. And in the absence of complete disclosure of sources by the defendants with evidence of their invoices and all, the total inventory seized by the local commissioners were handed over to the plaintiff for further scanning of the unique codes. So this was something which is different from